Hello, class. Welcome back. This is Professor Watson. This is Contracts, LGLA 1351. This is week 7, so we're on chapter 6 and 7 this week. We're talking about these last two elements or conditions of contract, legality and capacity. In the first lecture, we talked about legality and how maybe we need to think of legality as a little bit broader. It doesn't necessarily mean illegal, right? An illegal contract is a contract where the contract would be illegal itself, or where the subject matter of the contract would require somebody to do something illegal, is definitely not enforceable. But things that we may not think of as typically illegal, a court still may not enforce for illegality for things like the court's not going to enforce a contract which requires the commission of a tort. Or then we talked about illegality, maybe in the bigger sense of kind of public policy concerns. And we talked about some things like clauses in contracts, like exculpability clauses that may attempt to excuse in advance potential conduct. So an exculpability clause that excludes in advance intentional or even reckless conduct, right? Typically, those are going to be unenforceable for illegality. They don't necessarily violate a statute; they're not criminal, but they violate that public policy, right? We're not going to give people a get out of jail free card to go do something wrong, right? Whereas if you've got an exculpability clause that excludes a negligent conduct, well, then it's still going to be suspect, right? But the court's going to look at it to determine whether, kind of on these public policy standards, whether a covenant not to compete, something like that, is enforceable, right? We talked about the court's going to look at the big picture. Was this covenant not to compete part of a larger contract, a contract with some other legitimate purpose, or is it just a restraint on trade? Is it just buying off your competitors, right? Because if you're just buying off your competitors, well, that's not in society's best interest. We want as many competitors as possible, right? Whereas if you are if it's part of a larger legitimate contract, it may have a legitimate purpose, right? Like we talked about, if you wanted to buy somebody else's business, then they want to get the most they can for it, but you're only going to pay the most you can for it if there's a way to make sure that they can't just come right back in business and take all their customers back, right? So a covenant not to compete there can be very important. So is it connected with a larger legitimate contract or a contract with legitimate reason? And then we talked about kind of the balancing test that the court's going to do. And we talked about the court looks at whether restrictive covenants or covenants not to compete, those kind of things, are reasonable in scope times 3, right? Is it reasonable in scope of time? Does it last a reasonable time considering the business objectives and considering the interest that's to be protected, those kind of things, right? Is it reasonable in scope of a geographic area, right? Does it only go as far as it needs to in order to protect those legitimate business interests and those legitimate values? The last is the scope of activity, right? Is it reasonable in the scope of things that of activities that it prevents, right? Like Nike may have a legitimate interest in keeping Tiger Woods from selling any other brand of tennis shoes, right? But if Tiger Woods wants to quit golf and go wait tables at a Mexican restaurant, well, then let him work, right? What does that have to do with Nike's interests? When we're talking about covenants not to compete, we talked about kind of those standards, and those are important to memorize. That reasonable in scope times 3 is something that's going to come up in most jurisdictions. All right. We talked about some other places where courts may deem that contracts are unenforceable for illegality. With things like gambling contracts. And the reason we brought that up is not because this isn't a criminal law class, we're not worried about gambling, but sometimes contracts, some things that might look like legitimate contracts might shade over into that gambling category, right? If you're trying to insure against some loss that you don't really have a legitimate interest in, dead pools, those kind of things, right? There might be gambling, that might be unenforceable. We talked about things like usury laws. If there's specific statutes on those. If you attempt to charge an interest rate that is illegally too high, then number one, under the common law, the court's not going to enforce that contract as illegal. But you need to be careful when those statutes involved, because they may take it a step farther. Not only will the court not enforce your contract, they may not even allow you to rescind the contract, take it back, right? If you've loaned somebody money at a usurious rate, not only is the court not going to enforce that illegal rate, they may not even enforce the contract. They may let them keep the money. We talked about there's other types of statutes that may be similar, especially when it comes to like payday laws and consumer lending laws, but even commercial lending and mortgages and that kind of stuff. There can be statutes that say these are things that you can do in contracts. These are things that you cannot do in contracts. And if you do those things when the statute says it can't, then the court may not enforce it for illegality, right? But then we started to talk about, but what does that mean? Just because there is a clause in a contract that may be offensive, right, that the court may not want to enforce, does it mean the court has to just throw out the entire contract? And we talked about this concept of blue penciling, right? And that comes, I told you, from history, where back when we used to edit things, we didn't have word processors. And not we, I'm not that old, quit it. But in the day, right, before word processors and computers and that kind of stuff, when you were editing, if you wanted to strike something out, right, make an edit like that, you would strike through it with a blue pencil. That way people could see what was being struck out, see what was being removed. But a blue pencil was the standard to know that, yeah, we want this taken out. And so when a court severs, when they cut out part of a contract, right, they save the whole, but they cut out part of the contract, sometimes we call that blue penciling or severing. And in order to do that, a court has to determine that that clause is severable, right? What does severable mean? It means that, we can remove the part without killing the patient, right? We can amputate the leg, or we can take out the appendix, or we can cut out that offending clause, but the patient doesn't die. The contract doesn't die. The contract still has a purpose. And if the contract still has a purpose, when you remove the offending provision, then we call that severable, and blue penciling would be the court striking through that offending provision and then enforcing the rest of the contract. All right. Not always possible if the contract just has an illegal purpose, right? Like, you hire an assassin to bump somebody off. There's no blue penciling there. The court's just going to declare that one illegal and not enforce it. And they're probably also going to report you to the cops, and you're probably going to jail. But that's blue penciling and severability and illegality and all that kind of stuff, right? Okay. Moving on to Chapter 7, though. Chapter 7 deals with capacity, right? Capacity. Who has the ability to enter into a contract? That may seem like a simple question up front, right? I can enter into a contract. You can enter into a contract. But the law doesn't give everyone the ability to enter into a contract, right? You may be aware people under 18 usually can't enter into contracts, right? Again, this is the law. So there's not a black and white rule. It's not always people under 18 can't enter into contracts. And we'll talk about that today. It's that generally speaking, if you enter into a contract with an 18-year-old, it's not, with somebody who's under 18, it's not going to be enforceable, right? Similarly, if somebody is mentally incompetent or incapacitated, right? If you enter into a contract with somebody who's mentally incapacitated, that contract may not be enforceable. It might be enforceable. And if you're the party who is dealing with an incapacitated person, you better be careful. You're taking a big chance because it may be that you can't enforce the contract against them, but if they want to enforce the contract against you, or more likely, if their guardian or their ward or their attorney ad litem, right, wants to enforce the contracts against you, you may be stuck with it. So you may be giving them the ability to look at that contract and say, hey, yes, this contract turns out is in my best interest, so I want to keep it. Or saying, oh, no, I don't like the way this contract turned out. This didn't work out for me, and they can just undo it. You do not have that option. If you're competent and you're dealing with an incompetent party, you may not have that option. Okay, so let's talk about all that today. Let's look at Chapter 7. Let me again, I hope you've read Chapter 7, looked at the notes. Let's pull up the PowerPoint and see if it helps. All right, so we're talking about capacity. And the question of capacity involves whether or not the law views a party as legally capable of entering into a contract. All right, that's what we mean when we're talking about capacity. It really doesn't matter what you think. It really doesn't matter what I think. It matters, does the law consider this person or this entity or this thing even as being capable of entering into contracts, as having the legal right and the legal ability to enter into a contract, okay? The first thing that pops up, when we think about capacity is often minors, right? You're all probably aware that in most states, a minor is defined as somebody under the age of 18. At least that is the definition here in Texas. In Texas, if you want to know what the law is, look at Civil Practice and Remedies Code, section 129.001, right? I hope by now that you all can find those statutes yourself, just like that. That you've got that website bookmark, so you can go straight to it without having to log into Westlaw or anything else. You can just, bam, go straight to the Texas statutes. But if not, there's a direct link to the statute there for you. Can you find it yourself, though? You need to be able to find it yourself. So please look at that. That's a skill that you need. But what is the age of majority in Texas? Be careful. If you run that search yourself, make sure you're looking in the right place. Do not confuse age of majority, which has to do with a capacity and whether you can enter into a contract, that kind of stuff. Don't confuse that with age of consent. Okay, age of consent in Texas is different from age of majority. Where would you find the age of majority? How old do you have to be to enter into a contract? Well, that's in the Texas Civil Practice and Remedies Code. Where would you find the age of consent? Well, that's going to be in the Texas Penal Code. What's the difference? Well, age of consent has to do with sexual assault charges, statutory rape, those kind of things. When is an individual old enough to consent to adult activities, and when are they too young? That doesn't have anything to do with it, whether you're old enough to enter into a contract or not, right? And so make sure you're looking at the right one. Don't embarrass yourself. If you've got if you go to work and somebody wants to know what the age of majority is in Texas because they have a contract claim, don't go look up that section of the Penal Code, okay? Because that just has to do with consent in adult situations, doesn't have anything to do with contracts, all right? Here's the thing, though. Minors are given special protections under the law, right? Minors, we have this concept of parens patriae, that the government has the duty to look out for minors, to stand in the place of a parent and protect them, because it's easy to take advantage of minors, right? And so in the law, minors are given special protections, and they are deemed to be not competent to enter into a contract. What does that mean? It means that if someone enters into a contract with a minor, then the minor, or more likely his guardian or administrator, has a right to avoid a contract, which they entered into before the age of majority. So what would that look like? Well, if a minor enters into a contract and then turns 18, well, then the minor themselves, who's no longer a minor, may be able to sue to avoid a contract. But if a minor enters into somebody who's under 18 enters into a contract and they're still not 18, well, they can't even bring suit, right? They'd have to have a guardian or an administrator, somebody, come in and file suit for them to avoid the contract, all right? What does avoiding a contract mean? It means that such contract is voidable, okay? Voidable, not void. We've talked about this before. What does void mean? Void means that the contract is no good and the court can't enforce it. Voidable means that the court could choose not to enforce it, all right? What is the difference? Well, it means that the minor or the minor's representative can make the choice. They're the ones who were taken advantage of. And so if the deal turns out to be in the minor's best interest, then the minor can enforce the contract, or the guardian or the administrator can enforce the contract on behalf of the minor. The person who dealt with the minor does not have that same right. If you contract with a minor, you take your chances. You take your chances that the minor is actually going to pay off, or is going to decide that, yeah, this is in their best interest. Because if they decide that it is not, then the minor can come and say, hey, court, I want to avoid this contract. Just tear it up and throw it away, right? Whereas if you sue, the minor can say, or the minor's representative can say, no, we're good. We want to enforce this contract, all right? So you can't contract with a minor and then go try to get out of it because they were a minor. If you contract with a minor, you've given them all of the options, right? They've got all the opportunities to make the decision. There may be some exceptions to that, okay? Primarily in some more common situations where where the law has decided that might be unfair, right? Or it may be result, or if we strictly enforce that rule, it may result in some injustices or some unintended consequences. Okay. One of those categories that is a little more rare, but you might see it pop up, is where a minor is acting as an agent for an adult. All right. Now, we'll talk about agency in a few more chapters, but generally, when someone is the agent of another person, they're acting on behalf of another person. Okay. So a minor acting as an agent for an adult, it's not really the minor that is the party to the contract, right? It is the adult that they are acting on behalf of. And so in those situations, if a minor is entering into a contract on behalf of somebody else who is an adult, the courts may view that and say that that contract may be enforceable, right? So if you send your son or daughter who is under 18 down to the store to buy a loaf of bread and just put it on your account, right? We don't have many stores that'll do that anymore, but you used to have little neighborhood and country stores that you could go down and just put it on my tab and send me a bill at the end of the month. And if you send your son or daughter down to the store to put something on your tab, and then when the bill comes, you say, ha ha ha, I don't have to pay that because you entered into that contract with my daughter or with my son and they're under 18. A court may look at that and go, no, they entered into the contract with you. The minor was acting as your agent. The minor wasn't buying the groceries themselves. They were buying it for you on your tab at your authority, right, on your insistence. And so in that situation, a court may find that even though the contract was technically entered into by a minor, that the minor was acting as the agent for an adult, meaning that they had authority to act for the adult, and therefore the contract may be enforceable. Okay. Second situation that comes up sometimes is that sometimes there are special statutes passed for healthcare purposes. Some states have passed laws that allow some minors to consent to treatment, and then in doing so to become responsible for the payment. Okay, we see this especially in women's health and contraceptive care. Some states have statutes that say if a young woman wants to go to an OBGYN and seek care or seek prenatal consulting, pregnancy consulting, or even seek contraceptives, that they can go and they can consent to that care even though they're under 18. But if they consent to that care, if they're able to consent to that care, then they're also responsible for the costs, right? And so if we want to allow, 17, 16, 15-year-old to be able to go to the doctor and get treatment without consulting their parents, then we also have to, make that 16 or 17 or 15-year-old responsible for the payments, right? Otherwise, a doctor's not going to contract. A doctor's not going to provide care to a 15-year-old if necessarily if the 15-year-old can't be forced to pay. All right. Now, that's not a slur on doctors. Many doctors would, right? But that's just not their business. Their business their business is we provide care, we get paid. And so if we don't allow people under 18 to be responsible for contracts, that may cut down on the health care that is available to those minors. All right. Third category is an old one, going back a long time, and it's for necessities. Okay. Now, that could conceivably, in some instances, kind of carry over into medical care. But when we're talking about necessities, we're typically talking about things that are indispensable to life. Okay. What are those things? Well, that's usually food, shelter, clothing, right? You can't survive if you don't have clothing. You can't survive if you don't have shelter. You can't survive if you don't eat, right? Don't think 2024 standards, right? If your teenager tells you if they don't have a cell phone, they're just going to die, it's just not true, right? That's not a necessity. You can live without a cell phone. Think of more of this as Charles Dickens and Oliver Twist times, right? You've got a homeless, child, a street urchin who lives alone and is running around the dirty back streets of London just trying to survive. If they can't rent a room right? Then they're forced to live out in the cold because they're a minor, because they don't have any adult, because they don't have a guardian who can supply those things for them. That's not what we're going for with this law, right? The whole purpose of this law is to protect children, not to leave them homeless or hungry or naked. And so we developed an exception to that rule that if a minor is seeking necessities, and again, food, shelter, clothing, right? Food, shelter, clothing, those things generally considered necessities. Now, I agree the law is changing, more modern times. Might you find a state where a car, where a court decides that a car or some kind of vehicle or some kind of transportation is necessary in order to get to work? Maybe times are changing, but food, clothing, shelter, those are the main ones. Cell phone, definitely not going to be. And other than that, you may want to consult with with the common law in your jurisdiction to see if they've expanded that food, shelter, and clothing to include things like transportation or healthcare or something like that. Okay, so that's minors. Some exceptions to the minor rule, something called emancipation. What is emancipation? Emancipation is a court process where a minor can go file an application, can petition the court to, we would call it removing the disability of minority. So basically, a child goes to court and says, hey, court, will you declare me to be an adult, right? In Texas, it's governed by Texas Family Code Chapter 31. Other states have their own laws. But basically, it's where a child who's under 18 says, you know what, I need to be on my own. I need to be able to enter into contracts. I need to make my own decisions. And I can't just do it on my own. I've got to petition the court to remove this disability, to remove this incapacity. Where have we seen that? Did you all ever watch Modern Family? Ariel Winters was an actress on that show. When she was under 18, she was already acting. She was already making money. She had some kind of dispute with her, I think it was her mother or with her family. And so she filed an application to be emancipated, to be declared an adult by the court so that she could enter into contracts and such on her own, right? Okay, another exception might be fraud. What do you do if you were trying to do the right thing, right? You know better than to contract with a minor, because that may turn out to cause you damages, right? You may not be able to enforce that contract with a minor. You want to be very careful, and you're trying to do the right thing. So you ask about their age, and they said they were over 18. Maybe they even showed you a fake ID or something. What do you do in situations like that? In situations like that, the answer is very gray. You need to check with the common law in your jurisdiction. In some courts, in some areas, there may be a balancing test about, did they ask and did they act reasonably? There may be a difference on whether that person is within a certain age range, right? Like if a person is 16 to 18 and they say they're over 18, and maybe you're applying, but if the kid's under 10, then it doesn't matter what they said. They're obviously under 18, and so it doesn't matter if there was fraud. But you just have to check your state law, okay? If somebody, or the law of your jurisdiction, when somebody lies about their age, what effect does that have on a contract they entered into? I will tell you that it may turn on, depending on the jurisdiction, but if somebody lies about their age, it may turn on whether they are trying to use incapacity as we would say, whether they're trying to use incapacity as a sword or as a shield, whether they're trying to use incapacity offensively or defensively. Okay. What do we mean by that? Well, if let's say that a minor enters into an agreement to buy a Nolan Ryan baseball card, right? They think they're going to be able to sell it for $5,000, and so they go enter into a contract to buy a Nolan Ryan baseball card on credit for $1,000. And then they go and they're not able to sell it for $5,000. They're not able to sell it for $500. And so they go back and try to use incapacity offensively. They go back and file suit and say, hey, court, undo this transaction. Give me my money back because I was a minor when I entered into this contract. We'd call that using incapacity as a sword, using it offensively to undo something that hasn't turned out to be in your best interest. Okay. And if you do that, courts are going to be a little more leery, a little less likely to tear the contract up or to let you use incapacity in that way if you lied about your age. Whereas if you use it defensively, right? If somebody has sued you to try to enforce the contract and you say, hey, wait a minute, can't enforce it against me. I was under 18 when I signed the contract. Now you're using it defensively, right? You're using incapacity as a shield. And in that circumstance, courts may be more likely to, even if you lied about your age, to say, yes, we're going to allow you to use incapacity as a shield. We're going to avoid this contract, not allow the other side to enforce it. Okay. So when it comes to fraud, the best answer is you're going to have to do your research and check your common law. But it may turn, at least one element of that decision is going to be, is the minor trying to use incapacity as a sword or use incapacity as a shield. Okay. All right, next concept, a term you need to know, especially when it comes to minors and incapacity, something called ratification. Ratification. And we're going to talk about ratification again when we talk about agency. But what is ratification? Ratification is when you acknowledge or you accept or you take a contract that is invalid and you make it valid after the fact. Okay, what would that look like? I mean, if a minor is incapacitated, then how can they ratify a contract? Well, the answer is they can't while they're still a minor. Okay, but what if a minor enters into a contract when they're under 18, and then once they turn 18, they say, you know what, this was the contract I meant to enter, and it's in my best interest, and so I'm going to say grace and you know and accept this contract. Right? That's called ratification. All right. So after becoming an adult, if a minor ratifies the contract, well, then the contract is enforceable, even going back to when they were a child, right? Even if there's something remaining, some issue left over from back when they were a child, if a minor becomes an adult and then ratifies the contract, then the contract is enforceable, okay? Be aware, ratification can be express, but it can also be implied, okay? Modification can be express or implied. Well, what do we mean about that? Well, what I mean is if you sign a recording contract with 14-year-old Justin Bieber, right, and you dump a bunch of money into promoting him and to really hyping him up and getting his career started, and it's going gangbusters, the day he turns 18, you probably want to get him to sign something ratifying that contract, right? To sign something to say, yeah, I accept all the terms of this contract that I signed before I was 18. That would be an express ratification. After he turned 18, he is specifically signing something or specifically stating that, yes, I'm ratifying this contract. Express ratification. All right. But what if 18-year-old Justin Bieber on his birthday doesn't do a damn thing? He just keeps performing and you write him checks and he keeps cashing those checks. And, you say, hey, let's record another album. And he comes on in the studio and he records another album and you promote the heck out of that one. And when that album hits it big, Justin says, hey, you know what? I want to avoid this contract now that I'm 18 and a half, now that I'm 19. I want to avoid this contract because I signed it when I was 14. Well, he may be out of luck because he may have ratified that contract unintentionally, even though he didn't mean to. He ratified it impliedly by continuing to accept the benefits. Once he turned 18, he continued to accept the benefits of that contract. He continued to cash those checks. He continued to use those promotional obligations that were under the contract. He continued to record those kind of things. If you continue to accept the benefits after you turn 18, you may be deemed to have impliedly ratified a contract. Okay, so two different ways to ratify a contract. Those are important. That's dealing with minors and incapacity. What about incompetence? Mental incompetence. What if they're not? They're over 18, but they may be insane, right? That would be our lay word. What if we could just say, well, somebody's insane, they're crazy, they're nuts. They don't have sufficient mental capacity to enter into contracts. Well, it's important to understand that that first of all, mental incompetence cannot be judged merely by age or physical disability. Okay, merely by age or physical disability. If you don't have any arms or legs or ears or eyes, you can still be competent. Those are physical disabilities. When we're talking about mental incompetence, we're talking about mental disabilities, or it may not even rise to the level of a disability. It may simply be an incapacity. Okay, and there are plenty of courts that will find that you could still have mental capacity at 50 or 60 or 90 or 110. It is not a matter of age. It's a matter of what is your actual mental ability like. Okay. Generally, mental incompetence is the inability to understand the natures or consequences of your transaction. Okay. If you signed something and you didn't understand what you were doing, that may be mental incapacity, or the inability to act reasonably with respect to a transaction. That may be a mental incapacity. I'll give you an example. A friend of mine, her father had Alzheimer's, and her mother had passed away, and so she had moved her father in with him, but she had to go to work every day. And so she would leave him at home, and she would go to work, and she would take care of him while she was home, or sometimes she would go home during the day to take care of him and check on him before she came back to work. And then all of a sudden, she got a call from the vet after a couple of months and said, "If you do not pay this vet bill, we are not brushing this dog's teeth." And she said, "Well, first of all, who are you and what are you talking about?" And they said, "Well, your dad has racked up this giant vet bill, and now he's in here trying to get his dog's teeth brushed, and we're not going to do it unless you pay the vet bill." And she looked into it, and what had happened is she had taken away her father's keys, but he was still leaving the house, and there was a vet within walking distance. He had been walking his dog to the vet, having the dog's teeth brushed every single day, and they were just doing it, right? And then after a couple of weeks, couple of months, they decided the bill had gotten high enough that now they weren't going to do it anymore if they didn't get paid. And so, of course, she gave them a stern talking to, and of course they did not sue. But had they sued her father to pay for all those teeth cleanings, he would have had an outstanding defense for mental incompetence, mental incapacity, because he clearly didn't understand the nature of the consequences of this transaction. He wasn't able to act reasonably. He didn't understand that every time he went into a vet to have his dog's teeth brushed, it was like $250 a day, and he was going in daily, right? He didn't have capacity, even though he had not been declared incompetent yet. There hadn't been a court declaration. It was clear from the circumstances that he did not have capacity. He didn't have that ability to understand what he was doing. Okay. It is important to understand that mental incapacity has to exist at the time the contract was entered into. All right. And people make this mistake a lot. If you have capacity when you enter into a contract and later you become incapacitated, well, that contract is still binding. Okay. The mental incapacity has to exist at the moment the contract is entered into. It's also important to understand that mental incapacity, again, makes a contract voidable, just like it did with minority, right? And again, voidable means that the incapacitated person or their guardian or their custodian can seek to have the contract declared void. But if it's in their best interest, then the incapacitated person or their guardian or their attorney ad litem, whoever, can seek to enforce the contract. And so you've given that option where you don't have the option because you have mental capacity. You should have known better. So we give the option to the incapacitated person or the representative to decide whether or not they want to enforce the contract. That's voidable. Okay. It's important to understand again that incompetent, in order to make a contract voidable, that mental incapacity had to exist at the time the contract was entered into, right? At the time that agreement was reached. Go all the way back to the chapter on agreement. At the moment the offer was accepted. If you had mental capacity at that moment, then it doesn't matter whether you were incapacitated before. It doesn't matter whether you were incapacitated after. What matters is at that moment. And it is important to understand that the law does recognize sudden moments of clarity. Okay, that somebody may have dementia, or they may have arterial sclerosis. They may have some of these things that affect their ability. Maybe they've been incapacitated for 20 years, but all of a sudden they have a really good day. And if they have a really good day and they enter into a contract when they're competent, and then the next day they're incapacitated again. Well, if you can prove that, then that contract is enforceable. That sudden moment of clarity. More likely what you see is people who, sometimes we call it sundowning, right? When they wake up in the morning, they're fairly competent. They know who they are, they know where they are, they can make good financial decisions, that kind of stuff. But as the day goes on, as it gets later in the day, as their system gets taxed, they start to lose their mental capacity, right? In that situation, if you're going to contract with somebody like that, you need to be very careful, right? You need to be able to prove that at the moment you entered into the contract with them, that they had mental capacity. So evidence of how they were before or how they were after, that's some evidence of that may be some evidence of how they were at the moment of contracting. But what matters is what condition were they in at the moment the contract was made, if you want to try to avoid a contract for mental incompetence. Okay. That leads us to an interesting topic on intoxication. All right. Intoxication is absolutely a type of mental incapacity. How many people of you have been at a bar when your friend or your enemy, or even just some random guy in the bar is like, drinks are on me, I'm buying it for everyone, right? And we know that guy doesn't have mental capacity. He's drunk. He does not understand. We can go back to that definition of mental capacity. He doesn't have the ability to understand the nature and consequences of the transaction, right? He doesn't have the ability to act reasonably with respect to that transaction. So is he incapacitated? And you need to be aware that the law treats voluntary intoxication very differently. Okay, if you choose to drink and you choose to get drunk and then you go do something stupid while you're drunk, you may not be, even if you can prove you were absolutely incapacitated, you may not be able to avoid that contract. Okay, when you yell "drinks on me," free drinks for everybody, you may not be able to get out of that contract. All right. Some states just look at it and say, "Well, no, you were voluntarily intoxicated, so it's just not a defense at all." Other states may look at that and say, "Well, we'll give you a chance. We'll give you a chance to prove that the bar should have known you were incapacitated. If you can prove that the bar knew and took advantage of you, or if you can prove that the person you contracted with knew that you were intoxicated and took advantage of you, then we may let you off the hook and say that the contract is void because of incapacity." But be aware that voluntary intoxication is treated very differently from just regular mental incapacity. All right. Also realize that that's voluntary intoxication. If you are not voluntarily intoxicated, if somebody roofied your drink, or somebody spiked your punch, if you're not voluntarily intoxicated, then those same typical mental incompetence rules, mental capacity rules typically apply. Okay, but voluntary intoxication, be careful, that may be treated differently. And the court may look and see whether the person who was contracted with you knew or should have known that you were intoxicated, knew or should have known that you did not have capacity. All right. When it comes to mental incompetence, this is probably a good time to talk about powers of attorney. I just had this question the other day from a student. Who can be an attorney? What is an attorney? Okay. And you hear people talk about, well, I have her power of attorney all the time. Sometimes you even hear people say, I am her power of attorney, right? Well, let's get to the bottom of that so you can understand what the law is, and so that you can speak reasonably and responsibly about this stuff. All right. An attorney is just someone who represents someone else. An attorney is someone who has the authority to represent someone else. All right. So So the answer to my student's question the other day, can I be an attorney, is yeah. You can be an attorney right now today. All of you, whether you have a bar card, whether you've passed the bar, whether you've gone to law school or not, you can be an attorney. You can legally represent somebody else in certain circumstances. Okay, so if you want to buy a house and you need to go to the closing and you need to sign all the documents, but your husband or wife is going to be out of town, they can't sign all the documents, they're not going to be there. You can give them your power of attorney. You can give them your authority to act on your behalf. When you give them your power of attorney, they are now your attorney in fact. Okay, you have given them your power of attorney. You have given them the authority to act for you. You've authorized that. Now they are your attorney. They're not your power of attorney. They are your attorney. Your power of attorney is what they have. Okay. And that gives them the ability to go represent you in certain circumstances. In what circumstances? Well, in whatever circumstances you authorized. All right. And when we get to agency, we'll talk more about this. We'll talk about does that power of attorney have to be in writing? Can it be oral? It depends on the situation. Okay. But that's a power of attorney. An attorney is just someone who is authorized to act on behalf of someone else. Now, I'm an attorney at law. What does that mean? That means that I can represent you in a courtroom. Okay. Why can't you represent somebody in a courtroom? Well, because unless you have a bar card, there's a statute that says you can't give legal advice. You can't represent somebody else in a courtroom unless you have a law license. Okay. So that's the difference between an attorney and an attorney at law. An attorney at law is just a special type of attorney, right? And there's a statute that says you have to be an attorney at law to represent somebody in court. There's actually a couple of exceptions to that. There are not many. Don't go represent people in court unless you have a law license. But there are a few exceptions even to that rule. Okay. But an attorney is just somebody who represents somebody. An attorney at law is a special attorney who has the right to represent you in court. All right. That gets us back to this power of attorney discussion when it has to do with incompetency. All right. So power of attorney is the authorization to act on behalf of another person. And it is important to understand that the next step in the law is that the law says that a power of attorney can be revoked at any time. Okay, so you can grant somebody your power of attorney, you can give them the authority to act on your behalf, and if you do, you have the right to revoke that power of attorney at any time. Well, here's the rub. What if the person who grants you their power of attorney then becomes incapacitated? If they've already granted you their power of attorney, how can they take it back if they're not competent to do so? Okay. And so the law decided that the best way to deal with that is to treat any power of attorney as becoming revoked immediately upon someone losing capacity. Okay. So if somebody gives you their power of attorney and then they become mentally incapacitated, that power of attorney is immediately revoked. It's immediately extinguished. It has no more authority. Okay. All right. Well, what does that have to do with incapacity? Well, because sometimes that's the whole reason we want to sign a power of attorney or give a power of attorney, right? It's a planning document. We're trying to create something in case we live so long or we get so old or our condition worsens, right? Sometimes happens to young people. That's tragic. But you see it coming, and before it comes, you want to give somebody authority to act on your behalf should you become incapacitated. And if trying to do that authority just evaporated the second you became incapacitated, well, that would stink. What can we do about that? And the answer is, well, the law sets up a special kind of a power of attorney. We call that a durable power of attorney, or in some states we call it a statutory power of attorney because it's actually provided for in a statute. Sometimes just to make clear, we call it a statutory durable power of attorney. What is a durable or statutory power of attorney? Well, that is a very special document. It is a very special power of attorney that, again, is made for planning purposes. It is a very specific power of attorney that is designed to survive your incapacity. And it only survives your incapacity because there's a law out there that authorizes it. And therefore, if you want to grant a durable power of attorney or a statutory power of attorney, you better read the law and you better follow the law to make sure you follow its requirements so that you can create something that survives incapacity. Because otherwise, just a regular power of attorney does not. Let me give you an example. If you go down to the bank and your grandmother wants you to help her pay her bills, and so she gives you her power of attorney as an authorized signer on her bank account, right? You're an authorized signer on her bank account. That is a power of attorney. It is not a durable power of attorney. And if your grandmother becomes incompetent, the bank may, and they find out about it, the bank may and should cut you off. They should cut off your signing authority unless you have a durable power of attorney. Again, durable power of attorney almost always covered by statute. In Texas, you can see Texas States Code, chapters 751, 752. There's actually a form there that you can use. You can use it for yourself. Let me make sure I'm not getting anybody in trouble. Remember, you guys are not licensed attorneys, at least you're not yet. And so while you could use that form yourself, there's a full durable power of attorney form in the statute. You can print that out and use it for yourself, but don't go printing that out and giving it to other. Well, you can print it out and give it to other people, but don't give them any advice. Don't fill it out for them, because if you do, then you're giving legal advice. Then you're straying over into the unauthorized practice of law. Okay, so power of attorney. What is an attorney? What is a power of attorney versus what is a durable power of attorney? That's something important to know. All right. That's what we got for this week. So we've covered illegality and capacity. Remember, we had those 4 or 5 elements of contract: agreement, consideration, mutuality. We talked about that really in connection with consideration, right? Both sides have to give. Both sides have to get. It has to be mutual. And then this week we talked about legality and capacity. And now you see why I said, are those 4 elements or 5, or is it just 3 and then 2 conditions? We don't think most of the time when we draft a contract about, is this contract legal, right? Or is this contract illegal? Most of the time we're just doing our business, and as long as we don't think as long as we're not breaking the law, we don't worry about whether it's legal or illegal. Same thing with capacity. Normally, when we're entering into a contract with somebody, we don't think about, well, do they have capacity to enter into a contract like this? Because most of the time it's just obvious. Most of the time we don't even think about it. So do you want to call those elements of a contract? Or do you want to call those, 3 elements of a contract and then 2 conditions that have to exist? I don't care. I don't care how you count it. I don't care about the semantics. I care that you understand about how important legality and capacity can be to you and to your clients. If you're entering into a contract that may be illegal, you got to be real careful, because what's the use of entering into a contract if it's not going to be enforceable? Likewise, if you're entering into a contract with somebody who may not have capacity, you're going to want to be real careful, right? Because it may be enforceable against you, but you may not be able to enforce against the other side. That's kind of the worst of both possible worlds, right? Okay, so legality, incapacity, 2 very important concepts. That's what I've got for this week. That gets us through chapter 7. And so, not to scare anybody, but that means that next week you have a midterm exam. I will put up another brief lecture, brief recording to kind of explain your midterm exam that's coming up next week. Watch that, right? Before you freak out about it. It'll be long, it'll be challenging, but you can all ace it if you put in the effort. Okay, so before you freak out about it, watch the next recording. I'll try to get that up soon and kind of explain the rules and explain everything we're going to do for the midterm. In the meantime, if you have any questions, as always, please email me, give me a call, shoot me a text. I'm happy to talk to you anytime. Okay. All right. That's it for chapter 6 and 7, and I will see you in the next recording. Thanks. Bye.